Welcome to our second SCOTUS Focus over coffee. We reprised it due to popular demand. I think many of us are concerned over SCOTUS cases and rulings, so we're so pleased to have our two experts with us today. I'm going to give you some brief background about each of them. Professor Emerita Judy Brown taught as a tenured professor at Nuisance for nearly 30 years. She's the co-founder of the Judith Owens Brown Forum for Women in the Law. She and her husband Jim endowed the school's program and forum in 2021. The conference this year is May 13th, so keep that in mind. Since her formal retirement in 2000, she's taught constitutional law and continuing education programs, both at Dartmouth College and the University of Arizona. Judy, we're so pleased to have you with us today.
Thank you.
We also have Wendy, the Matthews Distinguished Professor. Her title is Professor of Law and Professor of Public Policy and Urban Affairs at Northeastern University. She holds a joint appointment because of her national leadership in interdisciplinary thinking and problem solving on issues related to healthcare and policy. She is also the faculty director for the Center of Health Policy and Law at Nuisance, a very well-known program here. She's a national thought leader on health and policy law, and she speaks and writes frequently on those topics. They both have taught con law, and she teaches it currently, right, Wendy? And not currently, coming up. I turn it over to both of you. Thank you so much for being with us again.
Thank you, Mielle. This conversation really got started last summer after Wendy and I each read all of the pundits who comment at the end of the Supreme Court's term saying, not to worry, everything's fine, they're getting along, they're being moderate, there are no major developments, and we can all breathe a sigh of relief and go home. Well, the pundits all thought that was right, and Wendy and I thought that was totally wrong. And that turns out, unfortunately, to have been correct. One preliminary observation before we get into the idea that there is no good news to be had. You've often heard me say, those of you way back when who took all my classes, that how the court did what it did is just as important as what the court did. And the shadow docket, which I want to talk about for a minute or two first, is a perfect example. The shadow docket is nothing new. It's simply an emergency docket. All courts have them. What is new is that the Supreme Court is now making substantive law on the shadow docket as opposed to the traditional merits docket. And at least up until yesterday, perhaps the greatest factor influencing the increasingly popular perception that the justices are not above partisanship is the shadow docket, and it's blatantly partisan use. Originally, as I said, it was designed as a process to help the court deal with emergency petitions and routine uncontested matters. It has become a backdoor, secretive way of making major policy decisions, such as changes in immigration enforcement, disputes over election rules, public health rulings barring religious gatherings during the pandemic, and of course, most recently, reproductive rights. It was rarely used until the Trump administration, but the Trump Justice Department used, indeed overused, the shadow docket to protect the government from adverse lower court rulings. Above and beyond the partisanship question, there are some serious institutional problems with the shadow docket. Emergency appeals on the shadow dockets are often decided in a rushed way without the benefit of extensive briefs, oral arguments, and lengthy written opinions. The court often reaches the wrong result because they're in such a hurry and because they don't have before it a full airing of the issues and the facts. I'm going to put on my Steve Subrin hat. The shadow docket ignores procedure. Procedural rules exist for a reason, that litigants should be given a chance to challenge a law before risking legal consequences if they violate it. Obedience to procedural norms is a sign of fairness, and it's also a sign of judicial self-restraint, the self-restraint Chief Justice Roberts is so proud of. Remember all those balls and strikes, no substantive decisions, just balls and strikes. And of course, the shadow docket eliminates transparency. The court should always explain itself and disclose how each justice voted. Handing down opinions at midnight hardly helps. We all know Wendy's favorite case, Marbury versus Madison. Remember the midnight judges that gave rise to Marbury versus Madison. So my point is very simple. The right-wing majority has used the shadow docket in the highest profile cases of this term. And now we're going to talk about the one you all have been waiting for. Wendy.
Well, thank you, Judy, and thank you, Mia, for organizing this. Great to see everyone. I'm going to turn in 30 seconds or 5 seconds to abortion, which is obviously what's on everyone's mind right now, but I hope we have time. At least we had planned that I'll talk later about the health cases, the public health cases. They're all shadow docket cases. And I want to really echo Judy's point about its importance, but it really, they have metastasized. You know, these little cases, and the court says, and Justice Alito said in the speech in the summer, oh, it's not precedent. But boy, they keep citing them, those cases, and the lower courts are citing them, and they're taking us in places that I don't think they may not even have intended, and I don't think the country has come to grips with where the shadow docket is taking us. It's very scary. But since we're meeting today, and since the Supreme Court heard arguments in Dobbs yesterday, I think I want to start with that. As I was telling Mia and Judy, I was driving yesterday and listening to the oral arguments in the car as I'm driving. Yay for technology that you can do that, except it's probably not safe driving. It was a really disturbing drive.
Let me just interrupt you for 1 second. I was doing Pilates on Zoom and listening to the oral argument at the same time, and that was pretty impossible to bring on. Sorry, Wendy.
No, as I was saying, I don't know that it's probably undoes the good that Pilates is supposed to do to the body and soul. It was really disturbing, and you know, we could talk about it for 90 minutes, and it's hard, and everything is still preliminary because I certainly am still processing this, as I'm sure all of you are. Let me just say a few quick thoughts. First, it was really striking to me listening to the oral arguments, to the extent that the question about whether the Constitution had a right to privacy was really not discussed, right? I mean, it was almost taken as a given that Roe was wrongly decided, that Casey was wrongly decided. And now the question is, well, should you go full flung and get rid of it? Well, there is stare decisis. Can you go for 15 weeks if things change? But the idea that the precedent itself was wrongly decided was something that was barely discussed, and frankly, even by the judges who we know will be in dissent. I mean, they sort of taken it as a given that their colleagues wanted to overrule. I also need to say, and I've spent most of the last 2 years immersed, is probably not surprising to you, in the public health cases. It seemed somewhat jarring to hear Justice Kavanaugh say in his explanation about why Roe and Casey are, unprincipled, that the Constitution does not directly address abortion. And I say that because, whatever you think about that, we could debate that. He's really happy to go way out on the limb to overturn precedent, to protect other substantive due process rights, including, and I feel like I'm surprised nobody said this, but free exercise, which has been, one of his favorite things. I mean, I think all of us know that free exercise, not to mention free speech, are only applicable to the states through substantive due process. And so there, the idea that somehow the Constitution demands some rights and not other rights just seems like they're forgetting, they're happily ignoring both a lot of doctrine and frankly, our history and a lot of history. Because substantive due process was protected by the court in good ways and bad ways. Remember Locke, long before these other rights that they now hold so dear. So it seems all a little strange to me. So if I had to bet, and I guess maybe I do for today, it seems to me that there clearly were 5 votes to go all the way. Now, of course, things could change. And maybe Roberts, who seemed, and if I had to bet today, I would say, well, he's going to concur in the judgment, but not in the reasoning. Maybe he's able to pull off some kind of, amazing deal and negotiate some kind of truce. I doubt it, but it's possible. He's good at what he does in that sense. I think what should be jarring to many folks on this call is they will wrap themselves in the flag of Brown versus Board of Education. I saw that yesterday, right? Brown versus Board of Education will be the justification for overruling Roe versus Wade.
That's just obscene. I mean,
right?
It's sad about that.
But that's where they're going.
Yes, you're right.
We'll also ignore the fact that the conservative jurisprudence to which they adhere arose originally before it arose in opposition to Roe. It arose originally in opposition to Brown, right? I just like they're gonna, but the ahistoricism of judges who claim to be originalists is truly galling. And if anybody wants me to talk about that for another 5 hours, I can. So what about the court's legitimacy? I mean, Judy talked about it. We hear so much about their legitimacy. There's been a lot of change. I think here, only making this up, guys, I have no idea if I'm right about this. I think they do care about their legitimacy, but I don't think they care about their legitimacy in the way most of the pundits think they do. Roberts might. I think Roberts cares about the party politic thinks and where their Gallup polls are going down. But I think that most of the justices, or at least the other 5 conservative justices, care about their legitimacy in their own circles. In fact, let's be honest, we all care about how we're thought about in our own circles. I don't care about what, Joe Schmo riding down Huntington Avenue thinks. I care about what my colleagues think of me. I think they care about what their colleagues think of them and what their colleagues in the Federalist Society think about them. And there has been a lot of writing in the last few weeks and months about how if they don't overrule Roe now that they have the votes, they would be acting illegitimately. I think that is the community in whose legitimacy and respect they care about. And the fact that the polls are going to, go down, I think that's not perhaps what is important to them. In any case, I think they're also true believers. I got to say that, I don't think this is just sheer hackery. I think some of the other cases are, but I don't think this is sheer partisan hackery. I think we have 5 justices who are deeply, truly believing proponents of the right to life position. So they see this as principled. And in some sense,
I think you're right. And what I was struck in the oral argument that the 3 potential dissenting judges kept saying, if you do this, you're going to undercut our legitimacy. And they seem to care less about that.
Yeah. Well, in fact, they think it's a badge of honor because in fact, maybe the Sotomayor and Kagan's and Breyer's arguments backfired because they was like, we're not going to respond to the public. We are going to do what is true and good, right?
Exactly.
So, they see themselves in that sense as they'll martyr their legitimacy for what they believe is what the Constitution and frankly their God requires them to do. I mean, I think they're true believers. I do want to talk one sec about SB 8 and the whole Women's Health versus Jackson, the Texas law, the Shadow Docket decision in the summer that got so much attention. And then earlier in November, the court heard full arguments about. In the last few weeks, there's been a lot of punditry saying, oh, well, they're going to, overrule, they're going to lift, they're going to enjoin the Texas, lift the stay and allow the injunction to go back into effect in Texas before they get to Dobbs. And that will show, their even-handedness, and then they can do what they're doing in Dobbs. That's possible. But I think now it may be more plausible to think that they are waiting on Texas or they were waiting to count the votes in Dobbs. And now they can dismiss the SBA case because, there's no underlying constitutional right. Maybe there'll be some dicta in that decision saying, oh, no, Texas, you can't evade judicial review. We are top dogs here. But the underlying claim was about the denial of review for a constitutional right. And so if there's no constitutional right, there's no claim. And by the way, don't lift the injunction because you're saving lives. And that's the point Ross Douthat made the other day. It's like, well, the Texas law is terrible, but it's saving lives. And, and if you're a true believer, and they're true believers, that's makes sense. The last two observations I want to make is the court may believe that overruling Roe, and they seem to say this yesterday, will end the litigation and the instability. Don't bet on that. It will invite litigation, right? It will invite states to challenge and to, reimpose bans on same-sex marriage. Some states may go further. I don't know if any states are going to try to recriminalize sodomy, but there will be future litigation around the right to privacy and same-sex marriage. Should the Republicans take control of Washington, expect the attempt to federalize the ban on abortion. And so the culture wars will continue, as will the litigation. With that, I turn it over back to you, Judy.
I want to stay on abortion just a little bit longer, because I was struck by three things. One, we never talked about the disparate impact. I know we can't talk about disparate impact anymore because we don't care about that, but they never talked about the disparate impact on poor women, women of color, undocumented women who cannot afford the money or the time.
The litigants did.
Right. But
the justices didn't care.
Justices did not. And Justice Barrett seemed to say, well, don't worry about that because adoption is so uplifting and so easy and such a wonderful experience. Just get pregnant, have the kid, and have the kid adopted. End of argument. That's just, that's never land. The other thing that really upset me is Kavanaugh and his constitutional bromides. He said, we cannot decide contentious issues. We have to be proponents of something called constitutional neutrality. I never heard of constitutional neutrality before, but neutrality seems to me when there's a race neutral state, which is Roberts's mantra, guess who always loses? People of color. When there's a gender neutral rule, guess who always loses? Women. Because constitutional neutrality means perpetuation of the status quo. So when before he exploded in part 2 of his hearings, when he was in part 1 of his hearings, Kavanaugh said, Roe is settled precedent. So somehow it morphed from being settled precedent to the subject of what he called contentious debate. And the court shouldn't be involved in contentious debate. So all of a sudden, the Supreme Court is supposed to stay out of contentious issues? Well, yeah, but not out of issues they really care about, which are equally contentious. So the attempt to wrap himself in the robes of a constitutional theorist is, that's annoying.
Can I share one little tip? I don't know if this is trifle about this. In a decision that was decided in 2018 by Thomas, National Institute of Family Life and Advocates, whatever, versus Becerra, 2018, free speech case, sort of, crisis pregnancy case. And the question there was whether the state of California could regulate the speech of crisis pregnancy centers, more specifically by compelling them to disclose that they were unlicensed, right? You think the most obvious thing, you go in, someone gives you a sonogram, you think you should know the person, they're in a training and reading one. Thomas said there, I'm coming back to your point, Judy. Oh, you can't regulate that speech because it's contentious. It's controversial.
Yeah.
So when the government is trying to support one side of the abortion debate, the controversy is a reason why the court has to come in and prevent the regulation.
Exactly.
Court wants to go the other way. The controversy is why the court should not have a right. Somehow, right? You know, there's no, and this is, I mean, I'm probably going out on a limb here because I'm, you know, where I've been going with all the health law cases. But if you said to me the court should just get out of the rights business, and that would include getting rid of abortion rights, I might even go there.
Sure, as long as they get rid of guns and religion and all the rights they care about.
But the inconsistency of that, of the way they're playing it right now, is so galling. And secondly, and I think this gets to what maybe you're going to talk about next, that only works if you're in a background world where the political system itself, the court, has not messed it up.
Exactly. Exactly. And that's a perfect transition to the other major, well, we had to pick and choose which horrible cases we were going to talk about. So in addition to the reproductive right cases, the voting rights cases are perhaps equally horrible. Once again, Justice Alito is the villain. I listened to, he's a nasty man. I mean, I've never met him, but I listened to him yesterday. He's angry and he's kind of scary. He's talking about true believers. I don't know. Voting rights. At the end of the term last year, one of the very last things that the court did, Justice Alito issued an opinion that killed what little was left of the Voting Rights Act. So let me go back a little bit. For years, the idea behind voting was to make the circle bigger. The more people that voted, the better it was. But then came Chief Justice Roberts. He's been an opponent of expanded voting rights from the get-go. When he worked for the Reagan Justice Department, he said, if we don't require proof of racial animus, voting rights will become affirmative action cases, another buzzword. So now the theory is voting is a zero-sum game. In other words, if we let them vote, our votes will be worth less. That's not good. That's also profoundly anti-democratic. Another Justice Roberts quote from another voting rights case: democracy does not depend on a level playing field. Oh, really? Today, we're seeing the results of that nonsense as the Republicans won't let Democrats even try to level the electoral playing field. They won't even debate the federal election reform laws. Now, historically, there have always been fights about who gets to vote. We, the people were white male property owners. Nobody else could vote. In 1870, the 15th Amendment extended the franchise to the newly freed slaves, and in 1920 to women. Nevertheless, it took the Voting Rights Act of 1965, for those of you who like the movie Selma, that's what they were fighting about. It took the Voting Rights Act and other federal laws, such as the Motor Voter Act, to put some teeth behind the amendment for Blacks and for women. Even then, however, Republicans who lost elections alleged voter fraud. Sound familiar? These allegations reached a fever pitch after Obama was elected, and then came Citizens United in 2010 and Shelby County in 2013. And after that, the floodgates opened to voter suppression laws. The last straw came this June with the Alito opinion. It was an Arizona case called Brinovich versus the Democratic National Committee. Now, in Shelby County, the Supreme Court tossed the operative part of the Voting Rights Act, the part that required any change in election laws from states who had been found to be discriminatory, to get those changes pre-cleared by the Justice Department or the Federal District Court. And the Chief Justice threw that out because there's no more discrimination. One night when you were sleeping, it all went away. And so we didn't need those laws anymore. And since we didn't need them, they became affirmative action laws. And that was a big no-no. So what that left of section of the Voting Rights Act, which was section 2, which said you can prove a voting rights violation by disparate impact alone. If there's a disparate impact on minority communities, that triggers a violation of section 2. Justice Alito gutted that provision, what little was left of the Voting Rights Act. He read new requirements into the statute. My favorite was voting restrictions commonplace in 1982, which was the most recent amendment to the statute, are presumed to be constitutional. Where did that come from? I mean, the whole idea behind that statute was to question the constitutionality of voting rights in the states. There is, of course, no such language in the statute. As Wendy said, it's totally ahistoric. But Gorsuch, who prides himself on being a strict textualist, he agreed, and he went even further in a separate opinion, saying the court should impose additional limits on the Voting Rights Act. Back to my point about the tone of the opinions and how they do things is probably more disturbing than what they do. During the oral argument in Shelby County in 2012-13, Justice Collier said, well, you can't trust Congress to vote against a civil rights bill, even though the bill was approved 99-0. And remember Donald Rumsfeld, stuff happens, or shit happens, as he said, during a war. I kept thinking of that when I read Alito's opinion. He says, Alito, that when a state imposes a usual burden, I have to read this because it's so strange to me, a usual burden on voting, I guess, as opposed to an unusual burden on voting, and the state can assert, but has no need to prove a significant interest in preventing voter fraud. In other words, if there's a little bit of a burden on voting rights, and the state says, well, we're doing this because there's voter fraud out there, even though there isn't any fraud out there, the law is perfectly constitutional. So bad things happen in war, bad things happen in elections, and there's nothing the courts can and should do about it. I guess that's constitutional neutrality again.
It sure isn't deference to the political branches that we heard so much about yesterday, right?
Right. And of course, you can't trust those political branches when they're voting on civil rights law, because
but you can trust them on abortion.
Oh, absolutely. Absolutely. So Justice Kagan said in dissent, voting is a law-free zone. And that's right. And look what happened after that. I don't have time to go into all of the voter suppression laws that followed. Most of you have been reading about them in the paper. About a month ago, the Brennan Center at NYU Law School, which is my go-to place for the data on this stuff, said there were at least that 19 states had enacted 33 laws making it harder to vote. And that's on top of all of the voter suppression laws that were passed after Shelby County in 2013. A few states have made it easier to vote, but that hardly counterbalances the scales. So now access to the ballot box, just like access to reproductive services, is going to depend on the state that you live in. That's not constitutional neutrality. That's picking and choosing. Now, voting rights are moribund. Reproductive rights are about to be moribund, but religious rights are expanding exponentially. So Wendy's going to talk about that and see if you hear the contrast. These are rights that the Supreme Court cares about.
Exactly. And I think, if they have to pick their top three rights, right, it's free exercise, free speech, and guns.
Guns.
So,
yeah.
The Establishment Clause, not so much. So it's not all of the First Amendment. But I will talk a little bit about free exercise, because I think of all of the things we're talking about, this is the place where Amy Coney Barrett's replacing RBG just made a dramatic and quick, whoa, whiplash change. It took less than a month, right? So talk about the shadow docket. Late at night, not quite midnight, I think it was about 11 p.m. before Thanksgiving Eve last year, everybody was waiting for the Supreme Court. No, nobody was waiting for the Supreme Court. People were thinking about cooking their turkey. The court comes out from the shadow docket with a case called Roman Catholic Diocese of Brooklyn versus Cuomo. And it struck a regulation on the capacity of religious institutions, churches, synagogues, mosques, during the pandemic in red zones. The state of New York was limiting capacity. And it was a quite stringent regulation. And to be fair, it was far more stringent than most states had. But also, to be fair, it wasn't in effect because they weren't in red zones at the time. Nevertheless, both the Second Circuit had found the law to be constitutional. It found it did not discriminate against religion because the state was treating lots of secular institutions similarly, or even in many cases more harshly, right, more strictly. The court from the shadow docket, late at night, on a holiday, comes down and by 5-4 vote overturns, I don't know, centuries of Southern law, right? And rules that the regulation, which was not in effect, had to be enjoined because the state was treating religion more harshly than some, not all, comparable, in the court's view, secular activities. What was really striking about the opinion, first of all, the language, some of the concurring opinions, yes, Alito, oh my God, Gorsuch, he needs to calm down. But what was really striking was the court cited no evidence. It did not care what the science showed. It just said churches are comparable to stores. It didn't care what the science showed. By the way, they're not comparable, the science shows. It didn't care about who had the burden of proof. Getting back to Judy's important point about procedure, right? I mean, you would have thought that seeking an emergency stay to have an injunction, right? To seek an emergency injunction, the claimant should have had some evidence. No evidence, none. Okay, really overturns hundreds of years of precedent. After that case, the court starts striking COVID laws, striking COVID laws, striking COVID law and free exercise grants. Just everyone. Perhaps the most troubling, although there were several that were somewhat similar, was in April, a case called Tandem versus Nuisance. And this is really a shocker. And this is again from the shadow docket, of course. California had a rule. California's been much stricter than most states during the pandemic. California had a rule that limited the number of households that could visit a private household. There was nothing about churches, synagogues, mosques. There's nothing about religion. You couldn't come over for book club. You couldn't come over for garden club. You couldn't come over to watch the football game, right? Only 3 households could come. Plaintiffs claim that they want to have Bible study at home, so that they should get a carve out from the law. The law shouldn't apply to them, right? You would have thought this was a generally neutral public health law, right? Under Employment Division versus Smith, Collier's 1990 decision, this was a sure thing, no brainer. Court says no, unconstitutional. Again, shadow docket, again, overrules district court, Ninth Circuit. Who cares of the findings? Again, cites no public health evidence. Yes, lots of secular, yes, secular activities are regulated, but hey, hospitals are open, train stations are open. So if people say they want to come and do something for a religious reason, they get an opt-out. This is giving, some people in the free exercise practice world call this most favored nation status. But I call it the get out of jail. It's the monopoly get out of jail card. If God tells me to do it, the law doesn't apply to me. This is exactly what Scalia worried about in Smith. And actually, in the case that Smith reportedly overruled or narrowed, Sherbert, Brennan was very clear that even then the state shouldn't have to prove a compelling state interest if it was a public health or safety issue, right? But now, in the middle of a pandemic, right, 500,000 people had died at that point. If you say God tells me to do it without any evidence as to the health impacts, then in June, we finally go off the shadow docket in a case called Fulton versus City of Philadelphia. This is from the merits docket. The city had a contract with a religious Catholic foster care agency. The agency did not want to place children with same-sex couples. The city said that violates our prohibitions against discrimination. The Supreme Court had taken the case and had actually taken cert on whether it should overrule Smith, the 1990 Scalia case that I just mentioned. In an opinion by Justice Roberts, 9-zip, unanimous decision, the court said they did not have to decide whether or not to overrule Smith, but they left it in such tatters that there ain't much there left. Because what they said is because the contract allowed the city the discretion to overrule its policies, you can imagine there might be a situation in which the only child, right, the only way to save a child's life, because of that existence, that hypothetical power of discretion, because it had never been used, the contract and the city violated the free exercise clause. And so again, if a religious entity wants an opt-out from a generally neutral law, an anti-discrimination provision seems like they can have it. A couple of observations about this, besides the fact that Smith is pretty much in tatters. First, it was clear to me that both Tandem and Fulton were going to invite reams of litigation about vaccine mandates. And so they have, and right now we have a split among the circuits about whether COVID vaccine mandates have to provide religious exemptions. But it's not just COVID, right? We've had vaccine mandates for polio and measles and right for hundreds of years. Well, polio not hundreds, but 60 years, and measles, smallpox for 150 years before that. All kinds of settled law are now being unsettled, right? Secondly, yes, Alito, 143-page concurring opinion in Fulton. He basically says anything that touches any religious claim needs to be compelling state interest, and basically should only survive the compelling state interest if it's a public safety law a la 1791. Again, he's forgetting the incorporation. And by the way, I can give you reams of public health laws that regulated churches back in in 1800 and 1790. Again, it's completely ahistorical. For hundreds of years, vaccine mandates have been assumed. I mean, there's no history about this. Again, then it's just really hard to know how far this goes. And this is the question, do they really mean to say that if I'm driving down the street and I say, well, I have to get to church, and it means going through a red light, and well, some secular, fire trucks can go through red lights, so why can't I? Because I got to be treated as well as any do they really mean to say that? that every time someone stops for a red light, they could say, well, God, you know, I'm on my way to pray. It's just, it's bizarro, I think. But this is, and this is to me one of the real issues, besides about how unprincipled it is, how historical this is. Well, first, no deference to a public, you know, where's the deference that they talked about yesterday? Where's the idea? You know, why is it that a woman's health should be left to the states, but your health against COVID should not be left to the states? Like, I don't understand why the state has more to say about reproductive health than it has to say about communicable disease. Okay, I don't get that. I really don't get it. Second, I mean, they're just inviting because they're going so fast and furious. Like Judy said earlier, they don't have the time to think it through, that I don't think they're thinking through the ramifications. There's an anger. Gorsuch keeps writing in all of the COVID cases, with a flick of a pen, a governor can take women's rights.
Like, women, go get an abort, you know, adopt, have the kid adopted, no big deal.
No big deal. But the flick of the pen, well, yeah, like governors sign every law. Like, they always used pens. Now they're probably doing electronic signatures. Like, what's with that? Right? There's an anger that feels more appropriate frankly, on Fox News than in court decisions. So whatever you think about the outcome of the cases, the rhetoric is, I fear, feeding into the culture wars. They are legitimating, even if they mean to do it, some of the angrier grievance-based, frankly, white Christian grievance-based anger that we're hearing, you know, in the far right. And to me, it's shocking, it's disturbing, and I don't know if they understand where it's leading to. But how does a country survive when a court, it's not that they're not protecting some rights and other rights, they are assuming such power, and they are making decisions without thinking about whether the country as a whole can survive as a country, never mind. They honestly do not care how many lives are lost.
So here's a perfect
example. The abortion decision, but lives are being lost because of COVID. And what they're doing, and I haven't talked about the vaccine cases, I haven't talked about what the Fifth Circuit did the other day about OSHA, but they're quoting the Shadow Docket and stopping OSHA from protecting people against COVID. This is where we are right now. I'm sorry, you can see.
No, this is just a little interjection. There's a case called Ramirez versus Collier about an inmate who was about to be executed. And he asked that his pastor or spiritual advisor, I can't remember what denomination it was, be with him and lay his hand on the inmate's shoulder to calm him down as he was being executed. And the court said, oh no, you can't have that, because that will interfere with the smoothness of that's a quote, the smoothness of the execution process and security while the death penalty is being administered. And the reason we're doing this is we're afraid of endless litigation. Well, they didn't want to help this inmate, so they were afraid of endless litigation. But in all the cases Wendy's talking about, they're not afraid of endless litigation. And here's that upset me the most. Judges are not competent to judge whether this inmate's claim of a religious belief was sincere. Now, remember a case a couple of years ago called Hobby Lobby, when religious affiliated organizations refused to cover birth control in their health plan, or even Hobby Lobby was a privately held corporation, but they said, we we run our business according to Christian principles. Footnote, they were under indictment at the same time for false advertising and lost leaders. Alito says, all you have to do is say your religious belief is sincere. How a corporation can have a sincere religious belief is another poser here. But all you have to do is say it. But this inmate had to prove it. Talk about inconsistency.
But also the other side too, right? You say, you know, they take at face value the security claim of the prison without evidence, but with reams of evidence, they don't accept California's claim about the public health impact during a pandemic. So, you know, they're picking and choosing when they care about evidence. They're picking and choosing, you know, when they defer or not defer to states. And they're assuming that they themselves know all the answers, right? I mean, what we're getting, and this is what I wrote in a paper that I have coming out, is, you know, what we're getting is jurisprudence by intuition, right? Like their gut tells them that you don't have to close churches during a pandemic, but their gut tells them that laying hands is dangerous in a prison. How do they know this?
There's no facts. No, let alone no legal argument. There's not a fact to be seen. No one has to prove anything anymore. So it's either their gut instinct or what they had dreamt the night before. I mean, so no wonder their approval ratings are going down faster and faster and faster. The court, you know, the court doesn't have military to enforce its rulings. Remember when Eisenhower sent the National Guard in during the school desegregation cases? But the justices are making things worse. Their integrity comes from the appearance of legitimacy, and they're not behaving in any kind of legitimate way. They're using provocative language, as Wendy says. They are openly denying the need to follow precedent, because they're monkeying around with the definition of when there's a real precedent and when there's just a regular precedent, whatever that means. That took up a lot of time yesterday during the oral argument. They claim that they're originalists, but they're acting totally ahistorically. They're manipulating the doctrine, often in ways that are ludicrous. Roberts has lost control. I said this to Wendy and she disagreed, so I'll say it again and you could disagree again. I think at the beginning, Kavanaugh wanted to look like a good little boy and he hid behind Roberts's robes. Now that he's got enough votes, he doesn't need to be nice to Daddy Roberts anymore, and he's gone berserk. But what seems clear is that Roberts has lost control.
He certainly has latched on to Gorsuch, and they've, you know, they're a pun intended soulmates here, and it's, yeah, I mean, you know, look, every now and then there's going to be a decision that feels a little bit more modulated, and the press and the media are going to say, see, you know, I mean, that was the headline of Fulton. See, they didn't overrule. But when you look at what they're doing, and this to me is one of the most distressing aspects, is they are seeding their opinions, even the opinions that on their face might not be such big deals. They're seeding them with red meat for the base. But what that does is it invites, it propels people to start bringing more cases. Sure. And it is empowering a cadre of, frankly, overwhelmingly Trump-appointed judges on the lower courts to then go further and further. And if you watch the way the COVID cases have gone in the last few months, you can, you know, it's like one case, a judge says this, and then the next judge cites the first case. And suddenly there's settled law that's 180 degrees different from where settled law was 4 weeks ago.
Right.
Yeah. And it's like a rush to it, and they're picking up and they're citing all of the most heated language in the Shadow Docket concurring decisions. So they're inviting a real dramatic attack, and we haven't had time to talk about this, but it's related. So on the administrative state, right? Court heard arguments the other day about Chevron doctrine, for those of you who are into, the weeds of administrative law. They are also reviving, to the point that I think it's clear to say it's alive and well, the non-delegation doctrine, and that's being used to strike down pretty much anything Biden wants to do about COVID. It's quite a ride right now. It really is. And
they're trying to counter this by running around the country loudly proclaiming that they are independent and impartial. And they look silly. I mean, Justice Breyer writes a simplistic and charming fairy tale book that says, oh, we're not like that. Justice Barrett goes to a ceremony honoring Mitch McConnell and says, we are not hacks, we are nonpartisan. Justice Alito says, fake news, the press is out to get me. That's where all this is coming from. I'm old. Remember Richard Nixon, I am not a crook? I keep thinking of that as these people run around the country in their robes. I am not a hack. I am a nonpartisan, wise, sagacious, Solomonic judge. They look stupid. I mean, they're not helping themselves. They're hurting themselves with this.
Here's where I'm going to push you, Judy. They're not helping themselves with you or me, but they're speaking, how could Barrett is not a stupid person, right? No. She's not. How could she be so like, what? Saying you're not political while you're being introduced by Mitch McConnell? Like, how could you really do that? You could do it because the audience you care about is a very different audience. It's not, it's obvious. She's not stupid to realize that, a lot of people in the country are going to say, oh my God, like irony is dead. How can she do this? It plays well on Fox News. It plays well in the next Federalist Society convention. That's her audience, and that's who they're talking to.
That's right, and that's the scariest part of all. The rest of us are kind of participating in conversations like this, saying how terrible it is.
But Judy, it goes to the fact that the rest of us are either like me and many probably here in blue Massachusetts, so we don't count. Sure. Or you're probably nicely gerrymandered, so and the Arizona legislature is going to, it's not going to take away your vote, but it's going to dilute your vote and make your vote effectively, and the state legislature. And by the way, would this court say state legislatures could take away the elected votes of, who knows? They didn't have to face it in last January, but who knows what they'll do in 4 years. So, it does at the end of the day, you're even though I live my life in the health law cases, the abortion cases, the COVID cases, the vaccine cases, I could name a lot of other cases that get me upset that we haven't talked about. It does all come down to the politics, and in a functioning democracy, the court can make mistakes, things can happen. I saw somebody in the chat, Ingrid asked about court reform, but in this moment, right? I mean, the court has, I don't blame it solely, but it has certainly aided and abetted the erosion of our politics and the polarization and the dysfunctionality. And so how do we get out of this? Court, if we were a healthy country, we could have court reform, but we need court reform to be a healthy country. I don't know how we get out of that.
And I don't know what court reform means. I mean, I think adding more justices to the court is like a dog chasing a tail. We add some, then they add some, then we add some. And then we're going to have to be like the big appeals court, hear cases broken down into small panels, and who's on the small panel is going to be a political choice. The more institutionally solid way to do this is a constitutional amendment. Well, that's never going to happen. So meanwhile, we're living in a theocratic, profoundly anti-democratic country.
And anti-science.
Yes, anti-science, anti-fact. I don't know what to do about it. And that's what scares me the most. I mean, when the Supreme Court started to go a little nuts some years ago, Justice Brennan wrote an article, not to worry, state constitutional law is the answer. And for a long time, in some states, that was a good answer. That's not going to happen anymore because the state courts are no longer as welcoming as they used to be. The door of the federal courts has been nailed shut. And I mean, I taught a course last year with a guy at the University of Arizona because can't you say something good to leave people with an uplifted feet? I said, no, I can't say anything good. I don't know what to do. And that's the scariest thing to me. I mean, you always went to federal court, do not pass go, do not collect $100. Then you went to state court. I don't know where to go now. And that's terrifying. I've spent my life worrying about the Supreme Court, sometimes praising them, sometimes criticizing them. Now they scare me. They have too much power. I was on a panel when Trump was first elected with some political science folks at Dartmouth who said, not to worry, because Congress won't let this guy get away with anything. And now we will have the image of democracy that the framers always intended, a strong legislature and a weak executive. Didn't happen. So I wish I could say something good. I wish I could say, here's what we should be doing. I'm not sure what we should be doing. I do think getting more people to understand what the court is doing is a tiny, timid little first step.
You do know, Judy, I'll share this with the folks on this call. I think Judy knows this. The reason I don't teach common law, even though if you look at my writings, I write only about common law, or primarily, is because I would not know what to say to a 1L right now.
Yeah, I agree.
I think it's actually really important that 1Ls, and since I'm talking, I think primarily here to grads and lawyers, and many of you know far more than I think I do believe it's important for it's important for our country that the next generation of lawyers, that young lawyers still have faith. I'm a little bit of cynicism, but also a little bit of optimism and hope, and that a belief that they can make a difference. Because if everybody just throws up their hands, you know, we're doubly screwed. But it's very hard for me right now to know how to give that to when it comes to constitutional law. And I think we all need to look, you know, not to state courts, but we need to, I'm not the one to do this, but, you know, the Democrats, progressives, people in the center have really gone for too long not thinking about state legislatures and state legislative elections and you know, local school boards, and they're reaping that strategy of over federalizing and of over relying on federal courts. So, you know, maybe we have to begin again. I don't know, like, you know, nothing lasts forever, and it's hard to see how this changes right now. But, you know, right? Brown overruled Plessy, nothing's forever.
Right. That's a perfect way to end. Such a pleasure to be able
So nice to talk to you,
again, Wendy.
So if I might interject, we had a couple quick questions. Would you guys entertain those? Someone asked about SB 8. Are you familiar with that and what the hints were?
Yeah, well, I thought I talked about SB 8.
Oh, you did. Okay.
Yeah, that is also the whole Women's Health versus Jackson and US versus Texas case. That's the bounty hunter law. And what I said was that I think, you know, I'm worried now that they're going to hold it and then say, well, you know, there's no under constitutional right to abortion. So what's the problem with the law? They might still rule on some of the jurisdictional issues, but they can also avoid that under constitutional avoidance. So I think the case is now, you could have imagined them 2 weeks ago focusing just on the jurisdiction, sending it back to the lower courts on the merits. But now, given where they are in the merit, on the underlying right, I think it's, you know, it might blend into Dobbs. Don't know.
Okay. And then we had a question. Do you think a June decision from the Supreme Court that overturns their guts row will mobilize Democrat and independent women in the midterm elections?
We can only hope. It would be good if that happened.
It would be, but I'm coming back, not being the, you know, just being, yeah, I think it might, but we've got this gerrymandering problem. We've got this voter suppression problem. We've got all of the other things that make it hard. So hopefully it does, but there's a handicap right now.
You could be mobilized, but if it's hard to get to the voting booth, and if it's harder to vote once you're there.
Or if everybody who's on one side of an issue are compacted into one district and the other side gets, you know, I mean, I don't know, Judy, you're in Arizona, right? Arizona voted for Biden, they voted for 2 Democratic senators, but how many Democrats in Congress from Arizona?
Yeah, Arizona's purple. And I live in Tucson, which is where the university is. So it's the precious little blue center. But they're in the middle of redistricting now. They thought they had an independent redistricting commission, which was upheld by the Supreme Court a couple of years ago. Well, a bunch of Republicans changed their party to independent so they could be appointed to the redistricting commission. So now we don't have an independent redistricting commission anymore. I mean, you
Being really crafty. Voting rights are absolutely essential.
Yeah.
I was pleased to see Stacey Abrams said she was going to run again. That was a little bright spot yesterday. You're getting lots and lots of love in the chat. 2 favorite professors. This was fantastic. Please come back to us after some of the decisions are made. So you have a big following now. I don't want to take up too much longer of everyone's days. I don't know if you each have a final thought or if you're thinking you're done, but we loved hearing from both of you and appreciate you both making time for this.
Just thank you to everybody who came. I wish there was an opportunity to have more back and forth. It gets somewhat complicated with a group this size on Zoom. And Judy, as always, let us keep going, keep talking. Love to do this again with you.
One of the chats said this too will pass. Maybe it will, and maybe we'll have some good news next year.
I hope so.
I really do hope that all of my worries are for naught.
Well, thank you both. Thanks for today and for your continued thoughts and input, and keep fighting the good fight, both of you.
Thanks, Miel. Thank you.
All right. Take care. Thanks everyone for joining in today.
Bye.
Bye, y'all.